Hello and welcome to Government with Dr. Turner. Today we're going to take a look at freedom of expression and how its protections have been tested. Freedom of expression is one of the most valuable liberties we have as citizens. Free speech is valuable because it helps create an informed citizenry. As participatory citizens, we need information from a free and independent press. If the press was restricted or only published what the state directed, we would not be informed enough to vote or petition the government. Free speech can limit corruption through criticism, investigation, and debate. Remember, the general tendency of mankind is toward corruption. Being able to speak freely gives us essential tools to fight corruption in government. Without freedom of expression, those who hold minority viewpoints would quickly find themselves without a voice. Censorship favors the majority opinion. Freedom of expression ensures protection of the truth and defends against known falsehoods. However, discerning the truth among all the noise in today's media is definitely a challenge. But even something as valuable as freedom of expression can be controversial. Freedom of expression demands that we protect all ideas, even those ideas we find distasteful or revolting. Not everyone in our society agrees that we should tolerate opposing viewpoints. Some believe that the majority opinion should always prevail. There are many types of freedom of expression. Speech that criticizes the government is often referred to as sedition. Just a casual glance through our history reveals that America has had little difficulty restricting speech it doesn't like. From the Alien and Sedition Acts of 1798 through the restrictions during World War II, Congress had no problem passing laws that made seditious speech illegal. The Supreme Court has never disputed the punishment of seditious speech, but has only argued how bad the speech had to be. The clear and present danger test was developed in Schenck v. United States, 1919. Schenck was arrested under the new Espionage Act of 1917, which actually remains partly in effect today. This test asked, does the seditious speech represent a clear and present danger to the United States? Paranoia and fearfulness of communist infiltration drove the passage of many speech-limiting acts in the 1940s and 1950s. The clear and present danger test was frequently misused in the 1950s and was soon replaced by the imminent lawless action standard. Outlined in the case Brandenburg v. Ohio, the standard asks, is the seditious speech likely to produce imminent lawless action? Speech, except when it is linked with action, is immune from prosecution. Symbolic speech can often incite deep negative emotions. Examples of symbolic speech include burning the American flag or the burning of crosses by the Ku Klux Klan. Burning the flag has been protected by the court twice. Congress attempted to circumvent the court by passing the Flag Protection Act, which was declared unconstitutional. An ensuing attempt at a constitutional amendment protecting the flag failed. The Supreme Court has ruled that symbolic speech is not protected when it is most likely to inspire fear of bodily harm. Ku Klux Klan cross burning is not protected if it is intended as a threat of violence, but otherwise it is protected as symbolic speech. Simply put, burning a cross in someone's front yard is not protected. Burning a cross in a field as part of an event is protected under the Constitution. Obscenity and pornography have created challenges for the court in producing a ruling. What is considered to be obscene or pornographic varies considerably from person to person, from state to state, and from time period to time period. According to the test outlined by the majority decision in Miller v. California, 1973, obscenity is to be defined by local standards. An interesting result of the obscenity debate has been the alliance of conservatives and radical feminists in opposition to obscenity. Recent decades have seen an attempt to limit fighting words and deliberately offensive speech. Fighting words are designed to produce violence. Limiting offensive speech has led to charges of political correctness. An example of political correctness is a university speech code outlawing demeaning language. Legislation in this area is rarely upheld by the courts. Also, offensive speech may have a political message which is always protected. A thriving and independent free press is essential for a well-functioning democracy. One threat of particular concern is prior restraint. Prior restraint means that the government forbids publication of certain information before it is published. The founders' opposition to prior restraint showed their commitment to freedom of the press. The Supreme Court has ruled that prior restraint may be upheld only in cases of extreme emergency. For example, in war reporting, the government may demand that the press delay publishing critical attack plans. Another freedom of the press issue is related to the power of the media to make or break reputations. In general, slander and libel are prohibited. The term libel can best be defined as printed defamation of character. Slander is spoken defamation of character. Private individuals can normally rest securely in the protection provided by these prohibitions. However, for public officials to claim libel, they must also prove malice. In other words, the press outlet must know that the harmful information is false and chooses to publish it anyway. According to the Supreme Court, public figures can win libel suits against the mass media only when the claims made by the media are known by them to be false or are made with reckless disregard for the truth of the claims. The court was essentially saying when individuals put themselves in the public domain, the public's interest in the truth outweighs the protection of their privacy. Finally, press coverage of a trial could potentially harm an individual's right to a fair trial. In the conflict between media access to a trial and a defendant's right to a fair trial, the Supreme Court has generally permitted press access to most stages of the legal proceedings. Let's review. Freedom of expression is one of the most valuable liberties we have as citizens. It makes democracy work better, it limits corruption, and it protects minority viewpoints. Sedition, speech that criticizes the government, has been limited by the courts throughout our history. Symbolic speech that is not a threat to personal safety is protected. Few court decisions have successfully dealt with obscenity and pornography. The court has mostly struck down any attempts to limit fighting words or offensive speech. The government may not prevent the press from publishing information, although the press may face legal consequences after publication. Public figures must prove malice to sue the media for libel.